Welcome back, corporations fans, and today we're going to talk about our third out of three concepts in the duty of loyalty here within the overall rubric of stockholder rights, those rights being to vote, sue, or sell. Here we're talking about the right to sue directors. Stockholders can sue directors for breaches of fiduciary duties, and now we are talking about that very important fiduciary duty of loyalty. And our third out of three lessons on the topic involves the Corporate Opportunity Doctrine. The Corporate Opportunity Doctrine is a subset of the duty of loyalty and addresses common director conflicts, and it generally forbids a director from diverting corporate opportunities to himself or herself. So we will talk about what is a corporate opportunity, what is within the interest or expectancy of a corporation, what is within the line of business of a corporation, what is within the economic capacity of a corporation, what is fairly within the auspices of the corporation. Did the corporation reject the opportunity? Those are the 5 tests for corporate opportunity, the tests as to whether an opportunity is in fact a corporate opportunity. So we will explore the meaning of these tests and then determine what happens if a director imposes themselves into the line of a corporate opportunity. A director may not divert a business opportunity that belongs to the corporation. As you could tell from the last slide, what is a corporate opportunity is worthy of some discussion. But we can say as a matter of law that a director may not divert that business opportunity to himself. That is a usurpation, and that director becomes a usurper, the evil usurping director who takes that business opportunity for himself. It belongs to the corporation. That is not how an agent should behave, not how a fiduciary should behave. That is a breach of the duty of loyalty, provided that the opportunity was of the corporation. The Corporate Opportunity Doctrine generally forbids a director, officer, or anyone in a fiduciary trust relationship from diverting to him or herself an opportunity that belongs to the person who the fiduciary duty is owed. In the case of a corporation, the director owes a duty to the corporation. If the corporation has an opportunity and the agent here, the director, diverts the opportunity, what is the remedy? What do you do? The remedy is to provide the corporation with the profits improperly derived from the usurped transaction. So where do we draw the line? How do we determine what is a corporate opportunity and what is not? And are there maybe some competing interests? Well, yeah. I mean, on the one hand, if we make everything a corporate opportunity, that really restricts what directors can do, and that may discourage them from being directors in the first place. Of course, on the other hand, if we severely limit corporate opportunities, then directors can steal from the company. So how do we balance this? Well, on the one hand, we need to deal with the potential for corporate expansion. The potential for corporate expansion permits a corporation or its shareholders to allege a director has siphoned, usurped, taken a potential deal that would otherwise make the corporation more profitable. The courts here attempt to identify legitimate potential for a corporation's expansion. So if a corporation has contracted, I shouldn't say contracted, that sounds like shrunk. I mean, entered into a contract for a potential expansion opportunity, like purchasing a new company. When Facebook bought Oculus Rift, they obviously wanted to go into virtual reality, right? That's what I mean by contracting, not contracting, but expanding by the virtue of a contractual relationship. The opportunity for expansion is clear. If the corporation is merely expecting to expand, if it hasn't contracted yet, if it hasn't engaged in a new line of business yet, how do we know that the corporation is going to? And why shouldn't the director take that opportunity for themselves? I mean, if Mark Zuckerberg wants to start a new company that does virtual reality and Facebook hasn't bought Oculus Rift yet, why would anyone think that a social media company would become a virtual reality company? Why couldn't he do that? Because that competes with the entrepreneurial interests of the managers. I mean, especially in this case, Mark Zuckerberg, he's an entrepreneur. He may have other interests. Maybe a better example is Elon Musk. So Elon Musk is a director of Tesla, which makes electric cars, and he decided to make a company that makes tunnels for superhighways underground. Why can't Elon Musk create a boring company, as it's called? Why should he be prohibited by the Corporate Opportunity Doctrine from digging tunnels in the earth because he's director of an electric car company? That's not entirely clear. Now, maybe Tesla could, in the future, get involved in the business of making tunnels because electric cars don't produce emissions. And by running electric cars through these tunnels, you have a much more efficient system of transportation. I don't know. But Tesla isn't invested in that. So we have this balancing interest. On the one hand, we want to preclude directors from taking, usurping, stealing opportunities for corporate expansion. But on the other hand, we want to allow corporate managers to engage in their own personal entrepreneurship. It's not uncommon for directors to sit on multiple boards. It's not uncommon for directors to start or invest in multiple companies that may or may not compete. We have to balance these interests. And so the Corporate Opportunity Doctrine tries to strike that balance. Not sure it always gets it right, but that's the concept. Balancing, on the one hand, the potential for corporate expansion with, on the other hand, the corporate manager's entrepreneurial interests. And like most doctrines, it's evolved over time. I'd like to start with a historic case. Let's talk about GUTH v. LOFT. This is a case from 1939. Pretty historic. I'm recording this video in 2019, so this happened 80 years ago. And it's interesting because one of these corporations persists. The other does not exist. So here's the facts. Charles Guth ran LOFT Incorporated. Didn't own it, not entirely. Shareholders owned LOFT Inc. LOFT Inc. was a retail candy store. The Coca-Cola Company refused to give Guth, and thereby LOFT, a volume discount for its soda products. It used to be that candy stores sold soda pop, soda fountains. Picture of it here for those of you who are not acquainted with the drugstore counter. In any event, Guth was miffed, and so he bought a bankrupt Pepsi-Cola company. He tweaked Pepsi's formula, reduced their prices, and served it in the LOFT candy stores. And importantly, LOFT paid for the startup expenses to reinvent Pepsi. Now, as you probably know, Pepsi thrived. They just sponsored the most recent Super Bowl. LOFT candy stores? Not so much. The LOFT shareholders sued Guth for the lost Pepsi opportunity. Did Guth divert to himself a corporate opportunity, the opportunity to buy Pepsi, that rightfully belonged to LOFT? Yes. Yes, he did. This was within the line of an expectancy of Guth. This was an unlawful usurpation of a corporate opportunity. Guth, the corporate manager, took for himself an opportunity he should have presented to the corporation. The classic Corporate Opportunity Doctrine states that a corporate fiduciary cannot take a business opportunity for him or herself if it is one the corporation can financially undertake, it is within the line of the corporation's business and is advantageous to the corporation, and is one in which the corporation has an interest or reasonable expectancy. Here, the candy store was already purchasing Coca-Cola products. Very easily could have expanded into upstream production of those products. Coca-Cola and Pepsi are substitutes. The court here found that Pepsi, the purchase of that Pepsi company, was an opportunity for LOFT. Charles Guth, as the manager of LOFT, he had an obligation that he did not fulfill, a duty of loyalty to LOFT to bring this opportunity to the corporation's attention. So we see the traditional corporate opportunity doctrine states A corporate fiduciary cannot take a business opportunity for himself if it is one the corporation can financially undertake. It is within the line of the corporation's business. It is advantageous to the corporation, or it is one in which the corporation has an interest or reasonable expectancy. Please note, this traditional approach is a relatively broad approach to the corporate opportunity doctrine, severely limiting the opportunity of corporate managers, balancing in favor of the corporation, because it focuses on potential harm, not actual harm. The corporation, LOFT, was not necessarily harmed. It maybe or maybe not could have done anything with this Pepsi company, but potentially that would have been very profitable. Now that's the traditional approach. Let's take a look at another case within the spectrum of the traditional approach to corporate opportunities. Servant Land Company was an entity created to buy land and build a golf course. Seriani and Savin were majority shareholders of that corporation. There were also directors and principal officers. Servant owned a 180-acre golf course and a country club. A third party, Farquhar, offered to sell an adjoining 160-acre tract of land to Servant. Now, this was distinguishable from GUTH v. LOFT because the directors presented the opportunity to the Servant shareholders at the annual meeting of shareholders for Servant Land Company. The shareholders did not take action to authorize purchase, and instead, the directors, Seriani and Savin, took the opportunity for themselves. What came of this transaction? 4 years later, Servant and Seriani and Savin sold the golf course and the 160 acres as an $8.3 million package. $5 million went to Servant, the company, the club, Servant Land Company. 3.3 of the 8.3 million went directly to Savin and Seriani, the directors, who had purchased Farquhar's adjoining 160-acre parcel. Farber, the plaintiff, a minority shareholder in Servant Land Company, brought a derivative action suit alleging that Savin and Seriani had taken a corporate opportunity by purchasing the land. The issue is whether Seriani and Savin took a corporate opportunity that belonged to Servant Land Company when they purchased the 160-acre adjoining tract from Farquhar. The answer is yes. They did. Under the doctrine of corporate opportunity, directors Seriani and Savin breached their duty of loyalty to the corporation by purchasing the land. And that's true even though the SLC, the Servant Land Company shareholders, did not take action to purchase the land themselves. And even though Seriani and Savin presented this to the shareholders at a meeting. Why did presenting the opportunity fail to cleanse this corporate opportunity doctrine violation? Well, the court looked at 4 issues in this case. 1. Did a corporate opportunity exist? 2. Did the stockholders decline the opportunity by failing to act? 3. Did the stockholders ratify Seriani and Savin's purchase? And 4. Did the subsequent benefit that the corporation received in selling its assets in conjunction with Seriani and Savin rectify any wrong it may have suffered? On the first issue, was there a valid corporate opportunity? The answer was yes. The sale of property adjacent to a golf course is a valid and significant purpose for a golf course company. After all, golf courses need land. The corporation was organized to buy land. It's called the Servant Land Company. It was organized to buy land. It was not even a close call. Obviously, an opportunity to buy more land is an opportunity for the Servan Land Company, which was organized to buy land. 2. Did the shareholders decline the opportunity by failing to act? The court ruled that the shareholders did not reject the opportunity because they lacked material information. Seriani was the president of the corporation and the only active director, and it was known that the shareholders relied on him. He told them not to take advantage of the transaction. Their reliance on him meant that they were missing important material information. 3. Did the shareholders ratify the director's decision not to act on the offer as a corporation? The court ruled they did not ratify. Again, the shareholders relied on Seriani's assertions and actions, and his assertions and actions were motivated of his self-interest. They polluted the process. He was not honest. There was no proper process. The manner of ratification, if such ratification occurred, rendered it invalid. The violation of the director's duties cannot be ratified by the actions of those who are guilty in participation in the wrongful acts. Seriani and Savin cannot bind Farber by ratifying their own acts, and the shareholders, as mentioned in number 2, couldn't ratify it because they were not aware. And 4, was the wrong corrected because of the sale and the profits realized? The court considered whether the $5 million profit to the Servan Land Company was enough to rectify the procedural defect. The court found that large profits realized by the directors were at the expense of the corporation. Servan was entitled to the $3.3 million profit on the other parcel of land. The court said if a corporate opportunity existed, the corporation and its stockholders would have been entitled to the profits from the sale of both parcels. Despite the undervaluation of their own property relative to the corporation's assets, Seriani and Savin made a handsome profit on the sale. The profits that Servan and Seriani made are effectively held in trust for the corporation. Those are the corporation's profits, not their own. The American Law Institute discusses these principles as well, and it finds that a director or senior executive may not take advantage of a corporate opportunity unless the director or senior executive first offers the corporate opportunity to the corporation and makes disclosures concerning the conflict of interest and details about the opportunity. Second, the corporation has to reject the opportunity, and the rejection has to be fair to the corporation or authorized by disinterested directors or ratified by disinterested shareholders, similar to the standards for approving a director conflict of interest transaction. But just like corporations can exculpate directors, they can also opt out of the Corporate Opportunity Doctrine through Delaware General Corporation Law Section 122. This may encourage certain types of enterprising directors to participate in the corporation, but it limits the corporation's ability to sue those directors accordingly. Delaware General Corporation Law Section 122 says that a corporation has the power to renounce any interest or expectancy of the corporation in or being offered an opportunity to participate in specified business opportunities or specified classes or categories of business opportunities that are presented to the corporation or one or more of its officers, directors, or shareholders. This is similar to an exculpation provision. But Servan Land Company did not adopt such a provision. So, returning to the case at hand, what is the outcome of Servan Land Company? In this case, Seriani and Savin breached their duty of loyalty to the Servan Land Company stockholders by usurping a corporate opportunity. There was a corporate opportunity because the sale of adjoining property to a land company would be used for a valid and significant purpose of an organization designed to buy land and build a golf course. That one was obvious. The shareholders, second, did not reject the opportunity because at the annual meeting, they did not have enough information to either accept or reject it. Moreover, they did not ratify the directors' decisions because they relied on Servan and Seriani's assertments and actions, and their actions of those directors was motivated of self-interest. They were confused and distorted by the motivations of the self-interested directors. Finally, the directors got large profits at the expense of Servan Land Company's profits. The remedy, the result, Servan Land Company is entitled to those profits. Merely because the company had some minimal benefit does not mean that they cured the problem. The entire benefit must flow to the corporation. So let's review. The Corporate Opportunity Doctrine is much broader, much broader than the duty of care, and broader, in fact, than the duty of loyalty generally. When a director obtains an opportunity that could even potentially be part of a corporate opportunity, it's a very good opportunity for the shareholders to sue. There are 5 major tests that have been brought up through time. The first is the interest or expectancy test. If the corporation has an interest or expectancy in the opportunity, the directors cannot usurp it without informed shareholder ratification. Or if the opportunity is within the same line of business as the corporation, that it is a corporate opportunity and likewise needs shareholder ratification if it's not to be taken by the corporation or taken by the directors. We also need to ask if the corporation had the opportunity economically to take it on. If the corporation is dead broke and the acquisition is expensive, we would not find the directors liable for taking an opportunity the corporation did not have the economic power to take on. We also apply a fairness test as to whether the opportunity, if taken by the director of officer, would be fair to the corporation. And when you get into concepts like fairness, obviously it's a facts and circumstances consideration. And whether the corporation rejected the test, ask whether the corporation, after full disclosure, rejected the opportunity by disinterested, independent corporate decision makers. It's a relatively high bar because you have to show they had full information, and it was then rejected by disinterested and independent corporate decision makers. We began our discussion of shareholder litigation with the duty of care. With regard to the duty of care, directors almost always win. We want directors to take risk, so we don't want to hold them liable for being slightly careless. It's very hard to distinguish between being slightly careless and taking an important business risk. On the other hand, we end our conversation with the Corporate Opportunity Doctrine, where directors often lose. I invite you to think about the type of risk that directors are paid to take, and the type of risk shareholders want directors to take on. On the one hand, shareholders have an appetite for business risk. But do they have a risk for people usurping opportunities from under their nose? I think the law is progressing in a direction where we're encouraging directors to take business risk, but hopefully discouraging them from taking advantage of their position of information asymmetry. Anyway, thank you for joining me. It was a great conversation about shareholder lawsuits. We spoke about the duty of care, the duty of oversight, the duty of loyalty, and the procedural requirements for shareholder suits. Up next, we're going to talk about stock markets and other ways shareholders can protect themselves from their right to sell their shares. I'll see you next time.